Good morning, everybody. My name is Jackson Friedman. I'm the Policy and Education Coordinator for the BC NPHA, and I will be your moderator today. I'd like to welcome you all to this morning's webinar, HR and Legal Considerations During COVID-19, which is facilitated by Simon Kent and Marcia Goldford. This webinar is presented by BC NPHA in partnership with Kent Employment Law and the Wisdom Group. We'd also like to acknowledge that this webinar is being delivered from various locations on the unceded traditional territories of the Coast Salish people, home of the Musqueam, Squamish, and Tsleil-Waututh people nations. We acknowledge that many of you are currently located in the ancestral homelands of Indigenous peoples across the province, each with their own unique traditions and history. At this point, if you have any technical questions or issues, please visit the GoToWebinar support URL at support.goto.com/webinar. Before we begin, I'll give you a brief outline of the format. The presentation will take approximately 45 minutes. This will then be followed by an open question and answer period for which we've allotted approximately 45 minutes, and our goal is to finish up by 11:30. During the session, please feel free to type in your questions at any time by using the chat feature, and then we will do our best to address all the questions during the open Q&A segment. The webinar is being recorded and the audience will be muted, which means that you can hear us, but we will not be able to hear you. Again, please type in your questions using the chat feature. A recording of this webinar will be sent out within a day or so. You'll be able to access the PowerPoint there, so you don't have to worry if you missed something today. At the end of the session, we will send out a quick evaluation survey to everyone, and we'd appreciate you taking a minute or so to complete it. Before we start the presentation, I'd like to extend a big thank you to our BC NPHA education partners whose support has enabled online professional development opportunities for the community housing sector. And I would also like to acknowledge Lisa Edwards, who is participating in the webinar. Lisa is a consultant for getthepicture.ca and will be creating a virtual visual recording of the webinar, which will be sent out to all participants as well. We look forward to the visual summary with key points from our discussion. I'd now like to introduce our presenters. With over 20 years of hands-on legal experience and a bold entrepreneurial spirit, Simon Kent is committed to redefining the practice of employment law. A veteran practitioner, he advises senior executives and company leaders and is the founding partner at Kent Employment Law, a boutique employment law firm with offices in Vancouver, Kelowna, Surrey, and Victoria. Marcia Goldford is a chartered professional in human resources with 15 years in management of nonprofit housing and over 20 years as a senior level HR and training practitioner. She is the founder and CEO of the Wisdom Group, a consortium of independent consultants providing expertise and support in administration to nonprofits and small businesses. Marcia is also a longtime presenter at BC NPHA events and online courses. I'll now turn the presentation over to her. Thank you.
Thanks, Jackson. I think we go to the next slide. You still have control. Hi, everybody. I hope it's as nice outside where you are as it is here. And I just, wanted to send one message to everybody. It's going to be okay. I know how tough this has been. I've been working with some of the groups. I sit on a couple of boards. You are essential services, so you're out there. Your people are out there every day and expected to continue to do their work in this rather uncertain and scary situation. It's how many times have you heard the word unprecedented? But it is unprecedented, and everybody is affected in the entire world. The situation is very fluid in terms of what we're learning about every day, new discoveries, new stats coming in, new problems coming up, new and creative ways of dealing with those problems, a lot of economic uncertainty, some light at the end of the tunnel. And through it all, of course, we all know how important our public health is, and I think we're all very grateful for the system that we have in place and see it working every day. And the heroes that are out there, I would like to acknowledge them as well. So people on the front line, like your own people who are working every day. We have a couple of polls. Jackson, or do you want to put the first one up there? If you could respond. How would you categorize your society's mandate? We're just trying to get a sense of who's in the room here and the kinds of services that you provide. So please select any and all that apply to you. And I don't know if we have any community living groups in there. You may not have any of those services, except for maybe group homes. So just please check other. Okay, so how did that fare? All right, so the bulk of the groups online today are providing housing, and some of you are providing homeless services, and this may be a combination. Mental health and addiction services, that's my society is in there, and that's where a lot of the challenges are in terms of shelters and working with people on the street. And the homelessness services as well. Assisted living seniors, 20%, and then other 24%. That's a good mix. I imagine most of you are providing housing in addition to some of those services. Second poll. Have you got that one? Great, okay. So what are the main challenges you're facing at this point in time? Insufficient staffing and irregular attendance. Are you getting some work refusals? People refusing to come to work out of a generalized fear and anxiety of what's going on? Is there difficulty as a result protecting frontline workers? Lack of clarity regarding your rights and obligations in addition to those of the employee? Lack of funding or anything other, any other? And please select all that apply. Give you a couple of seconds. How are we doing here? Okay, lack of clarity regarding rights and obligations. That's the majority of you. Well, that's good because hopefully we'll be able to provide some clarity today as we go through. If you have questions, please don't hesitate to put them in the chat at the side, and we will attempt to address them later. Anything that we don't get to or that we're unable to answer, we will be putting together some Q&As to send to you afterwards, so not to worry. All right, I think I'm going to get control now, right? Show my screen. Before I do that, I'll do this. Okay, so what we're going to cover today, I just want to talk very briefly about the current crisis. Why do I have that in front? I don't really want that there. I'm going to take myself off video, leave Simon. Hi, Simon. And yeah, that's interesting. Okay, you're very large on my screen. I wonder if I can reduce you. Sorry. Anyway, I'm going to talk about, we're going to talk a bit about the current crisis and some measures that you can take, and you probably are taking some of these measures already, depending on the situation. I think what happened initially was when this first hit and people were told to stay at home, things started to close down, and it became clear that it wasn't going to be business as usual. There was a lot of confusion and frustration at the very beginning, and I know that a lot of employees didn't know what to do. So, and employers as well. So as the weeks went on, you started, if you're like most of the groups I've been dealing with, you started to figure things out, establish some protocols, some procedures, get some clarity around what you could do and what you couldn't do. You started sanitizing, ordering supplies, and sending out communications. So I think that that hopefully has become clear as you've gone, and anything that remains we can hopefully address today. So Simon is going to talk about legal considerations. I'm going to talk a little bit about the government assistance that's available to both employees and to you as employers. I'm going to just talk quickly about some HR considerations. We're going to provide you with some links to resources, and then we're going to take some questions and answers. Just a little bit of good news, and I'm sure you guys are tuning in to Dr. Bonnie Henry every day. If you look at this slide, this was actually updated to yesterday, and the important thing to note is that the new cases of COVID are going down. The deaths in the province have leveled off. And while the total number of cases, of course, is accumulative, it's increasing. We are starting to see a flattening of the curve. So I have my rose-colored glasses on, and I would like to believe that at some point towards the end of May, we'll be able to see a little bit of a relaxation of some of the restrictions that we're facing right now. Some measures that you can and probably are taking, you can accommodate some of your workers are able to work from home. So I'm sure where you're able to do that, people are. That in and of itself poses some challenges, but for the most part, those people can communicate with you on a regular basis, and you're able to include them in meetings remotely. Technology is such that I'm sure you're able to keep in touch and work with people working from home a lot easier than you would have been able to, say, 10 years ago. You may be reducing people's hours because there may not be a need for them to be on site or be working as long as they have in the past. You may be rotating shifts, which is a good idea if there's a need to allow people to commute in at times of the day when they wouldn't have to be with the rest of the commuters. In other words, where they can better social distance, and also so that you're able to, avoid burnout. So people that are having to be on the front line or doing a lot of sanitation work that they wouldn't have done in the past, you're able to rotate the shifts so people can cover each other and overlap and spend time with their families at home, because that's the other aspect of this. Their kids are not in school. Flexible shifts, again, that goes in with rotating. That's just allowing them to work different hours than they would normally work. There are a whole ton of paid leave entitlements that are supported by EI, but then you have your own leave entitlements, vacation and sick leave. And then some of you may be using temporary layoffs for those who are non-essential workers, and maybe for those who have issues at home and they need to be at home. Well, that's more paid EI leave, but certainly temporary layoffs for those people who are not working at this point in time. Yeah. So, and then the alternative of that, which is some of you may be facing staff shortages because your folks are unable to attend work, your essential workers. So in that case, you'll be needing to staff up. So yeah, so those are some measures that you can take. And I'm going to pass it over to Simon now. And he's going to talk about some of the legal challenges that you may be facing.
Great, thanks, Marcia. So I guess just to start, I'll give you a little overview of what I am going to talk about today. So I'm going to touch on sort of employment law as it relates to the pandemic generally. We're going to talk about the issue of layoffs and what those are. We're going to move over to wrongful dismissal, talk about what that is. We'll discuss discipline during the pandemic. I'll touch on some rights issues and then finish off with some occupational health and safety. So the first thing I want to say about the pandemic and employment law is that you've heard this a million times, but these are unprecedented times, and we as employment lawyers live within a world full of rules around employment and how employees and employers interact in the workplace. The issue, and this is my personal opinion, but what you're going to see through my presentation is I believe that we're in a situation where a lot of the rules that we have lived by before are suspended, almost frozen in time. And you'll see what I mean when we talk about layoffs. So, I mean, I participated in a presentation a few weeks ago on this with other lawyers, and one of the other lawyers that was presenting really focused on, well, what are the rules that we have and how do they apply to the pandemic? And I just don't see, I see that there has to be a lot of flexibility built into what's happening. So I'll give you some examples as we go here. So the first thing I want to talk about is layoffs. So as I'm sure you're you've been hearing on the news or you're considering or actually implementing yourself. It's we're in trouble here. We don't have enough money coming in, enough revenue. We need to lay people off. So layoffs, if you look at the definition of what a layoff is when an employee is given less work or no work, with the plan that the employee will return to a regular work schedule at some time in the future. If you reduce an employee's hours by more than 50%, they're considered to be laid off. If a person is, it's not intended that they're ever going to be returning to work, that's a termination. When a person is laid off, they're still considered to be employed, and any benefits and entitlements, including vacation and leaves of absences, are protected. So here's the thing about layoffs, is that in my life before the pandemic, there really was no such thing as a layoff. If somebody contacted Kent Employment Law and said, hey, my employer has laid me off, that's a dismissal. It's actually not, there's only 3 exceptions to what I'm about to say, and I'll describe those, but you actually can't lay people off. Everyone has got an employment contract, whether that's in oral terms or in writing, and those contracts say, Simon, you come into work every day, do this just list of job responsibilities, and I will pay you for that. If the employer says, Simon, I don't have enough money, or for whatever reason, you got to go home and you're on a layoff, that's actually a dismissal, and severance would normally flow from that. So the 3 exceptions when a layoff would be permitted would be if your business is seasonal in nature, like for instance, logging, and everyone knows, and it's industry standard that no one's working during breakup, as an example. The second way that layoffs would be allowed would be if it was actually in an employee's contract. So it actually contemplated, there's a term in an employee's contract that layoffs are allowed. I don't know if I've ever seen that in an employee's contract, so very rare. And third, if the third way that a layoff can occur is if the employee actually consents. So in this pandemic world, an employer could go to an employee and say, hey, look, we're in trouble here financially, I need to lay you off, do you consent to that? But if they don't, and you still send them home, that is what we call a wrongful dismissal, or a dismissal without the provision any notice that the person's being dismissed, or severance in lieu of that notice. So, but if we look at the news, we see that there are currently millions of people, millions of Canadians that have been quote unquote laid off. And so that's what I mean by it's sort of the new normal. Traditionally, again, layoffs mean a dismissal, but in this case, with the pandemic, I've actually been advising my clients, yes, it's okay to go ahead and lay people off, even though technically that's not permitted. Of course, my advice would be try and get consent from the employee, but if you still don't get consent, then you have to, to save the business, you have to lay off. And then there's another element to that, which is something called frustration. So in contract law, if something was to happen between 2 parties that are in a contract, and of course an employer and employee are in a contract, if something was to happen, an intervening sort of outside event which no one could have anticipated, which then made the completion of the terms of the contract impossible, that's called frustration. So for instance, if I'm working at a factory and the factory burns to the ground and I don't have a job anymore and won't for a year, well, the employer would generally not be on the hook for paying any severance in that kind of a circumstance, because our relationship had been frustrated. And so some lawyers are talking about frustration. It's sort of a concept that's out there. Maybe it's a bit, complicated for this particular webinar, but that is one of the things that I think about when I think about my employer clients and how I'm going to have to defend them in the future if, for instance, some of these employees that are laid off start to ask for severance. I also have to think about, well, how is a judge going to handle this in some sort of court case where there might be an employee coming back and saying, hey, I never consented to a layoff. This is a dismissal, I want severance. And you can just imagine we've got hundreds of thousands of people in BC, if not millions, that have been laid off. So I'm not sure how a court, I can't imagine a judge in our Supreme Court or small claims saying, oh yes, I'm going to award severance to these 50 people that had to be laid off at X employer. I guess technically it's possible, but I think that we as a society and the court system is going to be a lot more flexible in figuring that all out. So
Simon, I have a question. I just want to jump in here.
Yeah.
What if you have an employee who wants a layoff, but they're not in a position that would be laid off? So they're still, say, a line worker and doing essential work, but they really don't feel comfortable coming to work. And if you're going to be addressing that later, that's fine. But I just wanted to put that out there right now.
Yeah, sure. It's up to the employer to decide if the workplace is safe and the employer is following all the guidance from WorkSafe, and you as an employer need that person, want that person, are not prepared to consent to them taking this layoff, then they have to continue to work. And if they choose not to, then you as an employer will have to decide whether you want to take that as an abandonment of their position, and therefore the relationship is over and no severance is payable. I mean, obviously you can't make a person work, but that's what would normally flow in employment law. It would be an abandonment of a position, no severance would be payable, and then you'd have to find somebody else to fill that position. But again, every time that I hear these questions from my employer clients or the employees, I always say the same thing during the pandemic, is that we all have to work together on this and have some flexibility. And we'll come to some of those other sort of fact patterns or issues as I talk here.
Sorry. If you have an employee who's not performing because they are so anxious and fearful, although even though their workplace is safe, but they are so fearful that you don't want to have them
right
there, can you take action to lay them off without their consent?
It depends on the severity of the anxiety. So if you've got an employee who is essentially paralyzed by the fear of getting COVID at the workplace, even though you have done everything reasonable to protect that person, then we start getting, take that example out of the pandemic and just stick it into our previous world when one of our employees is going through a difficult time. So employment law, say I've got one of my support staff members going through a very a difficult divorce or whatever's happening in their life, and they are suffering from anxiety and or depression. That then becomes a medical issue, and there's sort of this fine line between a person being worried and it being being worried and being sort of paralyzed by anxiety or fear. And at some point, it becomes a medical issue, which then you need to accommodate. Yeah.
Okay. Thanks.
Sure. So that whole thing about layoff and those examples I gave are those exclusions or when a layoff is allowed. That's all under the Employment Standards Act, just so you know. And so there's some rules around how long that layoff can last. So it can only be up to 13 weeks in a period of 20 weeks. It's interesting because I really, it's only through the pandemic that I actually opened up the Employment Standards Act and started reading about layoffs, because as I said before, in my 20 years of practice, I never even looked at it. It's a non-event for employment lawyers, because you send a person home against their will, that's a layoff, we're talking severance. Or that's a dismissal, and we're going to start talking severance. But now I'm talking to people who say, oh, it's perfectly fine to lay people off, but you can only do it for 13 weeks. That's actually not true. Right. Although, having said that, it kind of is true. It's almost like we as a society have agreed that this previous rule is suspended and that layoffs are somewhat acceptable, even in the face of an employee saying, I don't consent. And of course, again, here at the firm, we get, I would describe it as hundreds of inquiries from employees who are asking that very same question. I've been laid off. What can I do? Well, we could have a discussion about the rules, or we could have a discussion about the reality of the situation. it's you know, and things have really shifted, because as an employment lawyer, and I've been dealing with this for almost years now, where the employees sort of have the upper hand on the employer, because the employment world was so tight that the employees could pick and choose what they wanted and have all kinds of demands, and employers were just doing whatever they could to get good employees, to not only to hire them but to keep them. And now it's completely flipped, right? Where the employees feel, at least, that they've got no future whatsoever. That if they're let go, it's game over. And I don't know what the reality is. I think we will come back, and there will be full employment again, or at least the employment as we saw it before the pandemic, slowly. I'm just saying this because the discussions that we have with the employees who are calling us is, okay, well, we could write a letter on your behalf saying, hey, you can't lay this person off. They demand severance, but I mean, you've got employers that are never going to operate again, right? So if a general manager calls me from a restaurant that shut down, it doesn't make any sense for me to send a letter saying, this person deserves severance, because there may not be any money in the kitty to pay. It just seems sort of counterproductive of why everyone is just scrambling for money to just pay the rent on a per month basis. It's not helping by me sending those letters. So we have to have these hard discussions with employees and say, we're in a different world right now. You just better lay low, see what happens, and hope that you get brought back. And that's the thing here, is that I think my opinion is that the rules are sort of quasi suspended, but once we start to go back to work and a person who's been laid off is not asked back, that's a whole other kettle of fish, right? So I've had questions like, they laid off 10 people at my workplace, but my understanding is they're only bringing 5 back, and and they're bringing back the youngest, the cheapest people first. And I'm 65 and I'm paid the highest, and isn't that discrimination? And so I mean, Kent employment law is going to be beyond busy when we come back from the pandemic, because I can assure you that there are a number, hundreds of employers that are doing, that are not being good actors through this pandemic. Most people are, but I've seen some pretty crazy stuff so far. In panic to try to offload the liability of salaries. All kinds of crazy things are happening. So that's why we're doing the webinar today, and maybe we can help people avoid some of those missteps. Okay, so let's move on to wrongful dismissal. All these topics.
So I am having trouble advancing this slide. Oh, there we go. Okay.
Okay.
There we go.
Now, all of these topics that I'm discussing today, I could do sort of a one-day seminar on them. So I'm just going to quickly go through this at a high level. Obviously, I don't know any of the people who are participating in the webinar today. Maybe you understand these concepts, but I'll just go through them for those who the terminology is new, the concepts are new. So when you're letting an employee go, and you might decide to do that during COVID, there's two types of dismissals. One is for cause and one is without cause. So for cause would mean there's some cause for to terminate your employment, which then leads to us not having to pay any severance. That's pretty rare to see that in employment law. Even when an employer does fire somebody for cause, they will often lose a court case on that. So meaning that there's a very high threshold for when you're allowed to dismiss for cause and not pay severance. So some examples of a true for cause case would be to determine or finding out that someone has been stealing from your company. And even saying that, I'd say there's still a 20% chance that the court will find that there wasn't cause for their dismissal. So we are a little bit jaded as employment lawyers around the whole issue of cause, because I myself and the lawyers here have had a number of cases where employers are dismissed or do a dismissal for cause, and then at the end of the day lose, even when it seems obvious that the employee should have been dismissed for cause and no severance paid. So the other, obviously, the other way of dismissing a person is without cause, and that's what the majority of dismissals happen, and that would be what I'll call it a wrongful layoff would be. That would really be a dismissal without cause, and you would owe that person some notice or severance. So let's just talk about severance requirements. So you find the obligation to pay what I will just call loosely severance in two areas. One, and this is for provincially regulated companies, and this is all non-union I'm talking about. I do not practice union law, so everything I'm saying today is just in a non-union context. The first place you look for the payment of severance would be under the Employment Standards Act, Section 63, which sort of sets out the bare minimum notice or severance that has to be provided to an employee. And the maximum you'd get under the Employment Standards Act if you had been working for 8 years or more would be 8 weeks. So it comes from anywhere from 0, which is if you let a person go between their start date and 3 months, and it works its way up slowly all the way to 8 weeks. Now, that's just the floor, the bare minimum that you've got to pay, and you can provide that notice either in working notice. So you say, hey Simon, your employment is going to come to an end in 8 weeks' time, or however much time is required under the Act. Or you can pay severance, a lump sum amount, or keep them on a salary continuance, but not require them to come to work. Or you can do a hybrid, a little bit of notice, a little bit of severance. So that's just the floor, Employment Standards Act. And then there's the common law, or we call the judge-made law, and of wrongful dismissal. And that's where the big awards happen. That's where you'll see people get anywhere up to 2 years of severance for those who are, say, in their 60s and in a job that is quite senior and very hard to replace. One of our jobs here is to determine a notice period. So if an employer wants to dismiss an employee, they'll call us and say, here are the details of this particular person. So we're looking at what is their age, what's their job title, responsibility, compensation. Essentially, we're trying to get to how long do you think it's going to take this person to find other work with similar compensation scheme. And as I said, there's, it ranges. There's a huge range, and that's often what we're fighting about in court is about how much severance is payable. So here's the takeaway, the biggest takeaway from today. I think that's going to save you so much grief and money. Here it is, and this is going to put Kent Employment Law out of business if you actually listen to this. And that is that every single person in your organization needs to have a written employment agreement, and in that agreement, it has to say, upon dismissal without cause, and I'm just giving you like a précis, you have to get the real legal language here, but essentially, if we dismiss you without cause, the severance that will be payable to you is that which is limited by the Employment Standards Act. This is the maximum amount of severance that you will receive on a without cause dismissal. You're not getting anything else, right? So if employers only did that and limited their severance payable to the Employment Standards Act, this firm would go out of business, right? So you can always pay a person more upon dismissal, but at least you can fall back on that if you don't want to pay more and just say, it's 8 weeks is the maximum I'm paying here. You've been with us for 20 years, but I'm only paying you 8 weeks. We don't have the money for more, because if you don't have that in the contract, then that person calls Kent Employment Law, and then we write a letter, and the employer's in trouble, because you can pay sometimes, as I say, up to 2 years of severance. So you can imagine the difference between 8 weeks and 2 years of severance. That's worst case scenario. And all you needed to do was have a written employment agreement with a few sentences in it. But for some reason, employers can't do it. And I think one of the reasons is because it's like when you're in a romantic relationship and you're just starting that, and it really sort of takes the wind out of the love sails by saying, hey, would you sign this prenuptial agreement? And I think employers don't want to sort of scare off employees by talking about what's going to happen at the end. But it really does save a lot of heartache and a lot of time if you do that. Okay, so let's change the slide over. How are we doing on time? All right. So next up, the second slide for wrongful dismissal. There we go. Mitigation issues. So I just want to touch on these things just quickly. So if you don't have a contract that calls for has a severance limiting clause, and you have to call me because an employee is chasing you for severance, one of the things that comes up is what is that employee doing to find other work? So that can often be a battleground in court or in negotiations with opposing counsel in these wrongful dismissal cases. An employee can't just go home and lie on the couch and eat chips waiting to collect a big severance payment from the employer. They have to be shown to be making adequate attempts to find other employment. So again, and I always talk about what's going to happen in court, and I think 97% of our matters actually settle before, so they rarely go to court. But I always have to use that court as my anchor. Like, what would a judge do? And a judge would look at the work that the employee has done to find other work, and if it comes up lacking, the judge has the authority to provide less severance as almost like a punishment for them not doing the kind of work that would be required from a reasonable job seeker. Okay, retirements and resignations. These are just two other quick areas I want to talk about. I've had a number of problems with miscommunication around retirement. Just a quick example would be an employee who just constantly is telling you as an employer that they're going to retire, but never really gives a date. And then the employer, looking to make some changes, says, hey, you know, John, I take your last email to mean that you're retiring on May 31st, 2020. Thanks for the 26 good years. Good luck in your future. And there's no severance payable, and you know, it's just sort of comes to an end. And I've got into all kinds of fights around that on both sides of the employee-employer side. So you know, a retirement and we'll talk about resignations, has to be crystal clear. As an employer, you have to make sure that the person, and you know, get this in writing. Dear John, you know, my understanding is that you're retiring on May 31st, 2020. Can you please confirm? And then you even have troubles after that, because sometimes they'll rescind resignations or rescind retirements, and it's a real minefield for employers. It's really hard for us, because I'm an employer as well. It's really hard for us to do planning when people are flip-flopping. So a little bit of a minefield there, and the same with resignations. So we have lots of cases about people who, and especially right now with all the stress, people who have I describe as a bit of a blow up at work, and will say, you know, I'm out of here, or slam, you know, throw their pass and their keys down and say, I can't work with you anymore. I can't work under these conditions. And they storm out, and to any reasonable person, it looks like a resignation, but the courts would require you to provide a kind of a calming down period. So in that situation where someone storms out and swears and says, I resign, you actually have to give them a bit of time to calm down, and you need to follow up and confirm that they actually are resigning. Some employers just kind of go, oh, thank God that happened, and they said they resigned because I've been trying to get rid of them for years. But the problem is that if they change their mind and you say, oh, too late, you resigned, then they just get an employment lawyer, right, to write a letter and say it wasn't a true resignation. Unless you take the person back, you owe them, you know, a year severance, and it's a big mess. So you actually have to really confirm their intentions when things have calmed down. And then the final point here is the wrongful dismissal in a COVID-19 world. I've already touched on this, which is I don't know if the old rules still apply, especially in situations where they're determining what severance is. There's two schools of thought. Imagine that you laid somebody off wrongfully, and then they claim severance, and you refuse to pay or not pay enough. They took you to court. I'm not sure what a judge would do with that these days. Whether a judge would say, "Ooh, Mr. Kent, it's very difficult time. I think that this person isn't going to get a job for a year given the economic circumstances. So." I'm going to award a year of severance in the particular circumstance. Or is the judge going to say, these are very difficult times, Mr. Kent. It's quite obvious that most employers are under a lot of financial stress, and therefore I'm not going to award as high awards as I would in normal economic times.
Yeah. Sorry. So in terms of mitigation, I suppose that's kind of front and center, and a person's ability to find another job in the current economic climate would be difficult, right?
Yes. And a court is not supposed to look at the economic circumstance of an employer to determine how much severance is payable, but at the same time, I sort of feel like the courts are going to have some sympathy for where we all are as employers. but I don't know, right? What does it matter what I think, right? It'll ultimately be the judge that day, and we've got about 120 judges in the Supreme Court, and they all think differently. And so I'm just thinking, I'm getting old enough now to sort of imagine myself as a judge and what I would think, with my gavel, my wig. All right.
Does that just suggest people should be very, very careful about terminating employees at this point in time?
Well, I don't know.
Depending on the circumstances, of course.
Yeah, I really think it's very self-serving to say call an employment lawyer. You don't have to call me, but I really think it's worth paying for a little bit of advice through this time. I just see employers, end up paying. I always say, you might as well pay me $300 now as opposed to $20,000 later, right? But playing the odds. Another thing is, like, I just had an employer recently that let 50 people go, and I was a bit worried about the amount of severance that was being offered, and I thought, I think there's going to be a whole bunch of people that are going to come back, and they had 2 out of 50. They had 48 of them signed the release that went with the dismissal, and only 2 came back asking for more. So, and this is one of the things I talk to my employer clients about. You've got employees are, on the most part, they just don't want to get into the sort of any kind of protracted dispute with the employer. They just want to move on. So I'm not saying that gives you permission to act badly, but I think the chances of litigation are still low, even in this pandemic world. So I think if you move forward and you just be transparent and you treat people with respect, then generally things are going to work out. Like, if you explain to me that your organization is in dire financial straits and we need to do something, and this is what we're proposing, and try and get some buy-in, then that goes a long way. And just treating people like human beings goes such a long way. But if you don't, then what I see is when people feel disrespected and sort of tossed aside, they come in here and they say, hey, I've got $50,000 in my RSP, I want to deregister it so you can go and fight the bastards, right? And it becomes so emotional, almost like a family law matter. So the more that you can be caring and supportive and transparent and reasonable, respectful, the better. Okay, next up is Marcia really wanted me to talk about this next thing, which is discipline during COVID. There seems to be a lot of questions around what can I do during the pandemic period around disciplining people or employees. So the general areas around discipline are, I've listed them there on this slide. There's insubordination / disobedience, sort of a general failure to follow direction, refusal to work at all, and poor performance. So why don't we start at the bottom first, because that's easiest, poor performance. So I guess I would just say that generally nothing's changed. You can do the same things during the pandemic that you could do before that. I think there's obviously more stress associated with what's going on in the world, and is going to maybe cause more disruption at work and sort of general bad behavior. And I think we all as employers need to have more flexibility around that kind of behavior. But if you've got a person that is performing badly and leading up to the pandemic, and they continue to perform badly, you just use your normal processes around poor performance, which would generally be performance improvement plans leading up to dismissal. And if you do it the right way over a long period of time and you document it properly, you can dismiss for cause, meaning no severance, in a situation where there's poor performance. If the poor performance is associated with the pandemic, then I think we have to be very flexible. We have so many people. I mean, I've got lawyers here who are, trapped at home with their young children, trying to actually work as the kids are running around screaming. We have webinars where you hear the kids screaming in the background and sitting on their parents' laps, and you can just see the stress in the lawyers' faces, and just praying to God they can go back to work soon. So I think we have to be flexible around poor performance. And if the poor performance can be connected to some sort of medical issue, then you start getting into issues of discrimination. And so you have to, again, just be really transparent and open with people and say, so what's going on for you? And try to, almost be an armchair psychologist, try to figure out what's going on, what can I do to support you? So if the poor performance is related to the stress of the pandemic, be careful. If it's a continuation from before the pandemic, I'm less concerned about it. People who refuse to work. So I've got a client who wants to open up they've been shut down for about a month now. It's a store. They want to open up, and their employees that man the store are in their 60s, and they're refusing to work, even though my client is following all the guidelines of WorkSafe around safe work. And I don't know what to say to them about it, because half of me thinks, oh, just fire them. I mean, this is you've got a business to run. You're doing everything that the health authorities are telling you to do. For these people to refuse to work is a clear disobedience, right? But again, we're in sort of different times. I have great sympathy for people. Like I'm 53. I feel a bit susceptible to the virus. I can imagine if I was 63, I'd be even more worried about it. And so, and when we read the paper, we see the guidance from our healthcare professionals, it does shift, and that's not their fault. I mean, we still don't really understand the virus, how it's being transmitted. Are people who already have had it, can you get it again? How long are you actually, are you able to give it to other people? And so I have great sympathy for these people who don't want to work. So I think, looking at sort of the balance between my two thoughts on it, I would always go with the more humane approach, which is, okay, I understand, but you don't want to work. Okay, fine. But I can't pay you, so you just have to go home on a leave. And then, as an employer, just try and find somebody else who can work in that particular store, or do it yourself. It's not the best. And I think that if you did fire for refusal to work, you'd probably be okay legally. But there's that human element that I keep going back to, and I have a great sympathy in that particular example. And then insubordination, disobedience, again, it's all related to the sort of the stress, I think, of the pandemic. If I think it's like think of it as like dealing with some, if any, I'm sure a lot of you have children. I've got children. It's fine for people to have feelings, but it's how they express them that you still have the right to say, look, Jane, what happened in the lunchroom today was totally unacceptable. I know we're all under a lot of stress. I understand that. I hear that from you, but we have an expectation in our workplace that we're going to treat each other respectfully. We've got such and such policy. So it's sort of giving a little bit of support and love in a way, but also requiring that they follow certain behavioral parameters. Okay, so that's that. And oh yeah, so I'll just cover this next thing really quickly because I'm a bit slow here. So next up is something that I thought was interesting. There's a new protection under the Employment Standards Act. And originally it came out as you can't fire anyone during the pandemic, but that's actually not what it is. So the government came out with a new law, which they injected into the Employment Standards Act. And it says that essentially a person who has to go off leave for one of 5 reasons can't be dismissed. So let's just quickly go over those 5 reasons. So one is if you're diagnosed with COVID and you're following the instructions of a medical health officer, the employer can't fire a person because they're not at work as a result of that, or because they have COVID. Number 2, you're in quarantine or self-isolation, and or you're acting in accordance with the order of a health officer or something, or guidelines from the BC Disease Control Center. So a person can't be let go there. In a situation where the employer has directed them not to work due to concerns about their exposure to others, can't dismiss. 4, if the person needs to provide care to their minor child or a dependent adult who is their child or former foster child for a reason related to COVID, including school, daycare, or similar facility closure. So one of your employees has to stay home because no one else can look after the kids, you can't fire them. And finally, if the person's outside of BC and is unable to return to work due to a travel or border restriction. And this leave protection is actually backdated to January 27th, 2020, which I believe is the first confirmed case of COVID in BC. Okay, next up, quickly with human rights, nothing has changed. But just looking at human rights as it pertains to COVID specifically, an employer may not discipline or terminate an employee who has been diagnosed with COVID or is perceived to have COVID because, for instance, they've got certain symptoms. And also an employer may not discipline or terminate an employee if they are unable to come to work because medical or health officials have quarantined them or have advised them to self-isolate and stay home. So these are some protections under human rights. And let's move on to the second part of this, which is the Human Rights Code does not require employers to pay employees if they are not working or if there is no work for them to do because of the impacts on COVID. It is not discrimination under the BC Human Rights Code if an employer needs to lay off employees because there's no work for them to do as a result of COVID. So you see that it's interesting terminology. So that's from the human rights site. So in a way, it's giving you permission, like it's a little bit of a permission to lay off there, even though, as I've said, there really is no such thing as a layoff in a situation without consent. So, really that should say it's not discrimination if an employer has temporarily dismissed. Again, there's no such thing as a layoff, so I don't know what to do there. Has temporarily dismissed an employee. So anyway, we'll go with layoff, but it's not actually technically right. And finally, a medical note. So the government, under the Employment Standards Act amendment, has provided that an employee will not be required to provide a medical note if they need to take a leave. So you can't require a medical note from employees that are going off on leave because of COVID, but you're entitled to ask for reasonably sufficient proof that one of those 5 circumstances I outlined is actually in play. So I guess they don't want people tying up the medical system for getting these the doctor's notes, but you can ask for reasonably sufficient proof. Definition of what that means is not available, it's not out there, but you still, if a person's saying, hey, I need to take a leave, then, and it's one of those protected grounds, you still are allowed to ask for this some proof. Okay, finally, occupational health and safety. I think it's the stuff that we all understand. Employers have to take reasonable steps to ensure health and safety at the workplace. They have to follow the orders of the provincial health officer and guidance from the Centre of Disease Control in BC. And there's a whole list on the WorkSafe site of things that employers need to do. And I see these when I went to A&W yesterday, and they were doing all these things. So big signs up saying, hey, if you've got COVID-like symptoms, and this is both for people that are attending the store and who are working there, don't come to work. If you traveled abroad, don't come to work. If you live with someone with COVID-19, don't come. There is physical distancing maintained. There was only 5 people allowed in the A&W, and you had to stand on these little dots on the ground. And there has to be the personal protection equipment provided as necessary. There has to be adequate hand washing stations, regular sanitation, just the things that are sort of common sense, right? And so you as an employer have a responsibility to do all of those things. And if you don't, then trouble can come your way. So that's it from me, Marcia. Back over to you.
Thank you. Thanks, Simon. That was great. I'm sure we'll have some questions pertaining to what you had to say. Very, very important information, very helpful. I'm going to actually breeze through these because we've probably heard about all of them, but there may be some here that you're not that familiar with, and please ask questions and we'll provide some responses. So the first is the CERB, the Canada Emergency Response Benefit. That's available to employees that make below $2,000 per month or whose EI is less than $2,000 per month. People who have applied for EI and the CERB is higher, they will get the CERB instead. It's a very simple process. It takes 3 clicks. It's been a very efficient process to be able to claim and receive the benefit. It goes for 4 months. It's $2,000 per month or $500 per week. The BC emergency benefit was provided by the province. It's a one-time tax-free payment of $1,000 to eligible to employees, contractors, people who've lost income due to COVID. And I should say as well, the CERB is not just for employees, it's for contractors, gig workers, people who wouldn't ordinarily qualify for the CERB. They are entitled to it. It is taxable and people will have to pay taxes at some point in the future. There is enhanced EI leave benefits. So if you have a child at home or you have to provide care to somebody with COVID, then you can get compassionate care leave. For any of the reasons that an employer might lay someone off, that's for shortage of work, they are entitled to receive EI. Some of these EI benefits extend longer than others. So it might be worth investigating if somebody has two situations that they're dealing with, which would provide them with the longer set of benefits. And again, if the CERB is higher than that, they will get the CERB instead for the 4-month period, and then they will continue to get EI after that. I'm telling you these things because I think it makes us all feel a little better knowing that there is some income, there is some ability for people to be able to subsist at least during this period of time, and hopefully it won't go on too much longer and we'll be able to get people back to work. Again, there's an enhanced child care benefit per child that's available to parents of children, and for homeowners, I should say for people who rent, the homeowners are not allowed to evict for reasons of non-payment of rent. And there's this $500 payment for landlords for situations where people are unable to pay rent. It's just, it's kind of helping them through, although I can't imagine that $500 would cover everybody's need, but it is being provided by BC. There's all kinds of tax filing relief. The original deadline would have been tomorrow. It has been moved out to June 1st. And if you have any payments as a result of filing taxes, then if you have taxes owing, that's not due until September. ICBC has deferral options for premiums and crisis assistance. BC Hydro has deferral options and crisis assistance, so people aren't required to necessarily pay their monthly bill. There's free BC Transit in Vancouver and TransLink in Vancouver, and free BC Transit, I think, throughout the province. You guys would know better about that. And there's a moratorium on the repayment of Canada's student loans right now. In terms of assistance to employers, there's always been a work sharing program, and this program allows for employers to reduce hours for certain employees but still keep them whole. So let's say you want somebody to work 2 days or 3 days a week as opposed to 5. The work sharing program can help pay for the balance of that person's wages, and it's for a limited period of time. So what the federal government has done is extended the work sharing program so it goes for a longer period of time, and hopefully will extend at least to the end, if not beyond this current crisis. There's also a Canada Emergency Wage Subsidy, which supplements people's wages that are affected by COVID, where they might have seen a reduction in their work, and a temporary 10% wage subsidy on top of that. I think that has to do more with payroll taxes and benefits, but it's an addition. If you haven't applied for it, you should take a look at it. Every little bit helps, right? And then there's the insurance EI subplan, which again has always been there, but it's a useful tool. And if any of you, you might use it where somebody has mat leave and you're wanting to make them whole, then you're able to access, you're able to access as an employer an ability to top up their EI insurance so that they're getting 100% of their wages. It's something worth looking into during this time as well. The Canada Summer Jobs Program has been expanded and the deadline's extended, and the government is paying 100% of wages. And there's a huge increase in the number of jobs that will be covered under this program. So it wants students to be able to work. And obviously, if you're an essential services provider, you may be one of the few employers that's actually hiring. Don't forget to consider summer students for these jobs. And then I just wanted to put a plug in as well for the BC Nonprofit Housing Association Housing Job Match. And you probably know about this, you would have heard about this from Jill Atke lately, but it's a great little facility that helps you find people that are qualified in the housing sector who are looking for work. So definitely check that out if you're hiring. Bill payment forgiveness, I mentioned that. So for employers, there's also bill payment forgiveness from Hydro, ICBC if you have fleet vehicles and you have to pay premiums to insure them. There are deferrals. Gas credits for employers are available. The province is allowing you to defer your payment of the employer health tax. And then they're also allowing you to defer payment of PST and any other provincial health taxes, which would include hotel taxes, gas taxes, tobacco taxes, and things like that. I don't know how many of those apply to you, but if they do, it's worth looking into. And deferral of GST remittances as well. Also for employers, we know that we're not supposed to be evicting tenants for non-payment of rent. So those evictions are suspended. Other forms of evictions where the tenant is in violation of their agreement and there are fairly egregious circumstances, I believe that the RTB is entertaining those still. And then there's the Indigenous Community Support Fund, which is a huge infusion of cash to groups that are supporting Indigenous populations, and BC was given a pretty good share of that. So if you are a provider, works with urban First Nations or Indigenous populations, you want to take a look at that and possibly apply for that. Enhanced Reaching Home, the Reaching Home initiative is for the homeless and groups that support the homeless. And so there was an original call for proposals and it closed. And I think the first tranche of eligible, those who were eligible and who actually were awarded increased funding through this initiative, they were informed, but since then they have expanded that. So again, groups that receive funding or have received funding or would hope to should take a look at the changes and the expansion to the Reaching Home initiative. And again, for those groups that support women's shelters and sexual assault centers, there is increased funding during this time, and you should definitely look into that. There's also increased funding for the Kids Helpline. The government is doing as much as it can to support vulnerable populations, and of course, those are the people that we all serve. So it was great, Simon, that you mentioned the need to be respectful and considerate. I think when people are anxious, we tend to lose sight of how we are responding to people. And so it's really important to keep in mind that we are all in this together. For some people, they have anxiety and pressure not only in their work life, but they have it at home. And it was interesting that you mentioned that example where somebody at home has kids running around and they're having to deal with teenagers who are going out of their mind because they can't get out of the house and they can't see their friends, and there's only so much you can do on social media. We have to remember that everybody has their own set of issues and their own fears and anxieties around what's going on. So I just want to quickly talk about the need for you to have good policies, clear policies in place that address a lot of the issues that come up during a public health emergency. And so these are examples. You're going to get copies of these slides. Don't worry about writing these down. I want to put a plug in for hrinsider.ca. They are headquartered out of Penticton, They have, if you have, right now they're providing serious discounts to anybody that gets an account with them, but that account provides you with all kinds of policies, job descriptions, training, access to expertise, so it's to me it's a really cheap way of having a virtual HR department. And so I've just mentioned Jessica at the bottom. If you want to give her a call, you can do so. They also provide, and you need to have these on hand, the pandemic preparedness checklist. This is something that you can put together based on what you've done. And when this is all said and done, I would hope that most of you would take the opportunity to create a pandemic preparedness, a pandemic plan. So if in fact we run into this in future, you'll be really well prepared to be able to deal with it. And if you're not going to be there, of course, it's always helpful for your successors to have benefited from the experience that you're having now. So the COVID self-assessment tool, I don't know if you guys know about it, you probably do, but that's something that anybody can use to go on and assess whether or not they think they might have the virus. And so I would suggest anybody who starts to be symptomatic might want to take a look at that and go through the assessment. There's a workplace general precautions and risk assessment tool that you can use, and you've probably already passed that stage. You probably have already taken a look and evaluated the level of risk at each one of your sites and taken measures to address them. But if you haven't, this is a good tool that helps you assess that. There's a sample coronavirus and flu prevention memo, a screening form for coronavirus. There's all kinds of tools, forms, and notices that you can access that you don't have to reinvent the wheel. And again, I talked about a pandemic plan. This is something that is going to be useful for future and will be really well informed by your current experience. I encourage you all to take advantage. And I just want to say a few final words here, and that is that the health and well-being of both you and the people who work with you, both their physical and mental health is paramount in all of this. So you really need to take into account how people are functioning, what they might need from you. You want to communicate directly with people as often as you can. There's great resources, Microsoft Teams. I'm sorry, I'm having a bit of a blip here, but oops. Did I lose you? Yeah, sorry. Give me a minute here. I don't know why this is doing this. Okay. Oh dear. Okay. We don't need the calculator. Okay. Back. So there are all kinds of resources you can use online to have meetings with your teams and to do training, anything that you need to do to impart information. It's always good when you're telling people stuff that you quote the source so that they know it's a trusted source, and there are trusted sources, and then there's a lot of fake news out there. So make sure that you're being able to communicate information that is correct and factual. Always demonstrate leadership. So that means walking the talk. We can see some examples of people not doing that who are in leadership positions, and it never feels very good. And the other thing you can do is engage your board. Get someone from your board to send out a message. I don't know what I'm doing here. I'm hoping you're not seeing this stuff. Anyway, yeah, get someone for the board chair to send out a message to staff and encourage them and tell them, that we're thinking of them and that there's acknowledgement and appreciation for everything that they're doing. So that's my HR message to you. We do have some resources for you, and there's links to any of these, all of these that will be provided Simon at Kent Employment Law has some videos that are very informative. I have on my website COVID-19 resources page, and then BCMPHA has a ton of resources as well, and they're constantly being updated. So if you need any information at all, there's no shortage of where to look. Great. Okay, so that's me. I just wanted to move over. We're going to take some Q&A. I'll pass it back to Rachel or Tanya.
I'll take it over from here. Thank you so much, both Martha and Simon, for that excellent presentations. That was great. We've got about 20 minutes left, so we'll do our best to get through as many questions as we possibly can here. And what we can't get to, we'll send out as much information as possible after the webinar, so folks have access to getting answers to some of those important questions. But again, we'll do our best here. So the first one, and I've seen it come up a couple of times in the Q&A section, is about PPE. And so an example here is that my workers are part of a hotel union who said workers need to wear eye protection and haven't been able to obtain some. And that kind of goes along with some other questions about not being able to access PPE for workers. What should employers do in situations like that?
So eye protection, I assume, would be the face shield. I'm going to make that assumption. So they're not hard to find. And I think that anybody who's been able to acquire face shields might want to get in touch with BC Nonprofit, let them know who their source was and where they can get them. Other than that, eye protection would be goggles, which you can get anywhere. I don't know. Do you have anything to add, Simon?
I do not. No.
Okay. Yeah, so face shields or goggles might work.
Yeah. I'm going to jump into a bit more of a legal question. So one of the people that have submitted a question is, what about part-time workers that were usually working about 25 to 30 hours a week? They've only been moved to about 4 to 8 hours and have only been at the job for about 6 months. Is that considered a layoff?
Yes, or that would be considered to be a dismissal, or a constructive dismissal. I'm not sure who knows if you understand that terminology, but a constructive dismissal is when a person has something that has changed in the person's contract such that it's like they've been dismissed. So these part-time workers, I'd have to know a few more details, but let's just assume that they've been working 20 hours a week for the last 6 months, or that's what they were hired under. I mean, a person can be hired as a casual part-time person, and if the terms of the contract are that your hours will vary each week, that's one thing. But if we assume that a person's been hired as a part-time worker with a provision that they'll be working 20 hours a week, and then that's reduced to 10, that is a fundamental change in that person's employment contract, and therefore why they haven't been dismissed outright, they've been constructively dismissed. And so the first contract comes to an end, and in a way they're being offered another contract, this time with fewer hours. But again, in this post-pandemic world or pandemic world, it's almost like we as a society have accepted that it's okay to reduce that person from 20 to 10 in the short term. And that, and of course, as I said before, if the employer can get consent for that change, then great. If the employee is upset about it, then you just say, well, I'm sorry, it's just the way it is. We just don't have the money to pay you full time. We hope to bring you back as soon as possible. And then if that escalates, then the employer will just have to deal with that later, either by themselves through employment standards or call an employment lawyer.
They would be able to access the assistance that's available as well, right, even though they're working part-time.
Yep.
Great, thank you both. Simon, I think you mentioned this in the presentation as well, but maybe just a quick refresher. We've got a question. What about a dismissal for an employee who is still within their 3-month probationary period and they're not meeting the requirements of the job, or they're showing mediocre work and the employer would like to let them go? How should they proceed?
Sure, just continue with that. If the employment contract has a probation period, then the courts require that you demonstrate that you have to be able to demonstrate that you've given them a chance to prove themselves. So I actually say to employers, don't in an employment contract, don't actually put a probation period, just put a nice tight severance limiting clause in there. So if your severance limiting clause says that you'll only receive in severance or notice the amount that is payable under the Employment Standards Act, then between 0 and 3 months, the person gets nothing. So you're just allowed to let them go and no severance is payable because there's none that's payable under the Employment Standards Act. If you put in a probationary period, then the courts have actually said, you got to show that you've given this person a chance to perform and that they haven't been able to do that. So it's actually harder to have a probation period in a contract. And I think you should stay clear of that. But you guys are getting pure gold today in employment law advice, pure gold.
I want to just add to that,
yeah.
Because I know that most of these groups do have probation periods and they probably would have already hired people and they're in the course of those. But when you have an obligation as an employer to resource and train the individual, and you have a vested interest in them succeeding during their probationary period, which means that you have to train, you have to provide the resources, the contacts, and all the rest of it. But it also means that if somebody is failing, you should be telling them that. So you need to give people a heads up. You need to do interim or reviews during that period. If it's a 3-month, then maybe after month 1 and month 2. And if they're failing, they need to know why. So I mean, I've seen situations. More so with unions, obviously, but seen situations where employees they don't have a clue, and then all of a sudden their employer says, "Well, you didn't pass probation, we're letting you go." So that is not that's a recipe for trouble, I think.
Yeah, and sometimes the person's just not a good fit, and that's a hard thing to explain. So just taking the other side of that, Marcia, I completely agree with what you're saying. But if you're an employer who doesn't want to mess around with check-ins and supporting people and all the things that Marcia is talking about, which is great practice. But if you don't have a probationary period in your contract and you just decide the person's not a good fit because the personality is just the puzzle pieces are not coming together, then you can just dismiss immediately, no severance, if you follow my advice there.
Yeah.
Thank you both. This one is a little bit more around privacy. So the question is, my employee had a COVID-19 test. Can the employer require a copy of that result? The employee wants to return and the employer wants to ensure that it is negative as they work in a senior's home.
I'd say yes. The privacy is so difficult. What a minefield that is. Wow. Actually talking about this in the last webinar I did, just around this concept about you're all working as a group and in the back of an office, and one person, or you're told. Well, I guess the question was, what is your entitlement to being told if someone has got COVID? Are you entitled as an employee to know who it was? And a lot of people are saying, no, you're not. You're just allowed to tell everybody somebody in the office has been diagnosed with COVID-19, and we're taking the necessary precautions. But I, as an employee, would like to know who it was, because it may be that I went out for a smoke with that person, or I was in the cafeteria with them, or I remember that day that he came out of the men's stall and stood beside me and we had this talk. So sometimes I feel that the concept of privacy goes a bit far, so it's always a balance. So for me personally, I think in that scenario I described, I think the employer has a right, if not a duty, to disclose the person's name who has it. Now, people would disagree with me on that, fair enough, but I think that the employer in that posed question, it's like they have the right to have medical confirmation that the person has COVID.
And doesn't that feed into contact tracing as well? I mean, if somebody is in contact with that individual, then at some point others need to know, and so they can deal with it. The other question that comes up from time to time is taking people's temperature and whether or not that's a violation of privacy.
I don't think it is. I think in this, and where we're at right now, the taking of the temperature is acceptable.
Okay.
Yeah. Okay.
Thank you both. I'm going to jump to another one here. If staff have been laid off due to COVID-19 and have been paid severance as per the Employment Standards Act, do employers have an obligation to hire them back?
Well, it's not a temporary layoff then. It's a dismissal. Yeah.
Well, yeah, that's right. But you can see it's just the wrong use of terminology, but everybody does it, right? So sure, if a person's been dismissed and is been paid the employment standards money. Okay, so the answer to that is if you've got an employee, as an example, who's been with you for 10 years, and you decide that you're going to dismiss during the pandemic for lack of work or revenue, you just know that this person's not coming back, or this is a great opportunity to actually clean house. And you pay that person the Employment Standards Act monies. I'm going to ask you, well, what does it say in their contract? So does the contract say that the severance is limited to the Employment Standards Act? Because if it doesn't, then you've just paid them that first tier of severance, because they're going to come back, you're going to get a letter, or they're going to come back to you and say, well, thank you for the 8 weeks, but you owe me a whole lot more than that under the common law. And in fact, I want 10 months. So you haven't, that's only if they do come back. If they don't come back, you're fine. But theoretically, you have not extinguished your liability in that circumstance where you don't have a severance limiting clause which is connected to the Employment Standards Act.
What if you have them sign a release?
Okay, so great question. So if you paid them the 8 weeks and well, first of all, you can't ask a person to sign a release when you're paying them the employment standards monies because that's what they're statutorily required to receive. So you have no right to ask them to release you from liability for the payment of something that they're entitled to by statute. Some employers do that, but that would not be found to be enforceable. But let's say that they were only entitled to 4 weeks under employment standards and you gave them 8. So 4 under employment and 4 under employment standards and 4 under the common law against a release. And they signed that release, and then they thought about it or went and got legal advice and found out that they could have asked for 10 months. Then there's a problem. Then the court, or depending where this is heard, is going to do a little bit of examination around the circumstances in which that release was signed. So to protect yourself, employers, you want to do things like give the employee ample time to consider the release. So at least 5 days. So this whole thing about sign now and I've got a check for you, that's going to work against you. So you want to send them out to think about it. Some employers, the bigger employers, actually give employees money to go and see an employment lawyer to get advice. That's a great way of protecting yourself. And what else would there be? Then sometimes the employees will come back and say that they felt under some duress. They really needed the money for their family in the face of a pandemic, so they would sign anything. But now that things have calmed down, they realize that this wasn't fair, and so they say that the agreement was unconscionable. So it's when you're sort of taking advantage of a weaker party, the court can undo releases. So just getting someone to sign on the dotted line is not a guarantee that you're protected forever. So there are some steps you could do to sort of bolster that protection.
Thanks.
Yeah.
Thanks, both of you. I think we may have time for just 1 or 2 more questions here. This one is, do I as an employer need to continue extended health benefits for employees on temporary layoff?
I would say that temporary layoff, well, again, there's no such thing, but if they consent to the temporary layoff or there's those 3 exceptions to when a layoff is acceptable, then the answer is yes. Employment standards are required that those benefits continue. Beyond that, if you're just sort of forcing people into a layoff, then you're already in a bit of hot water. It'd be, I think, to your advantage to keep people on benefits if possible. If you can't and you cut them completely off everything, and this is not a consensual layoff, you may attract some problems in the future when the pandemic's over.
And I just want to add that from everything I've been reading, they suggest that you do keep benefits, particularly extended health and dental. Not that anybody can go get any dental right now, but extended health is something people will need for medications and treatment. So the best advice is keep people on benefits. It's also an indication of your intention to bring them back.
Right. The other one issue that crops up for me, and I don't know the answer, but would be long-term disability. So some workers will be part of these extended medical plans, which include coverage for long-term disability. But very often a policy will say that you can only get LTD coverage when you're actively working. So this no person's land of layoff, I'm not sure. And the problem here for employers is that imagine that someone goes off on this this layoff, quote unquote, and they become sick. So they get something happens in which they would qualify for LTD. You know, could the insurer come back and go, no, this medical issue happened when they were on this layoff. They weren't actively at work. So you, employer, are now on the hook for paying 66% of their wage between the age of 38 and 65. Good luck with that. And that happens. So actually, I didn't really thought about that. So some of you may want to get on the phone right now and call your policy provider and see if people on this on a temporary layoff, quote unquote, non-consensual layoff, would still qualify for LTD coverage. That's a bit scary.
Mm-hmm.
Yeah.
Great, thank you. Let me just jump to our final question here. I think we've got time for just about one more. This is a question about length of shifts. So this is about somebody who works in a shelter or an employer for shelters. So we generally have staff work at our shelter for 8-hour shifts. We have, due to COVID, changed to 12-hour shifts to limit the amount of people in the facility per day. And we now have decided to continue with 12-hour shifts. We've decided to do averaging agreements for full-time staff, but how does this affect our casual staff, whom we largely rely on? Do they have to be paid overtime past 8 hours per day, or can we only pay overtime after 36 hours per week?
Wow.
We might have to take that one offline.
Half of that question I wasn't listening to as someone was trying to barge into Marcia's office there.
Yeah.
Doesn't matter whether a person's casual or not. If they work more than 8 hours a day, they have to be paid time and a half. This is in a non-union context and an employment context. So independent contractors do not fall under the Employment Standards Act, nor do unionized workers generally. But if you've got you have an employee who is a casual worker and they work more than 8 hours a day and they're not on an averaging agreement, you've got to pay time and a half. And if they go over 12 hours, you've got to pay double time. So that's my thought on it.
I agree. I think so.
Okay.
Yeah.
Having said that, I'll often, I don't do this anymore, but I'll have someone call employment standards here to get some guidance on something that we can't figure out. And if you call 3 different people from employment standards, you'll get 3 different answers. So yeah, I know I'm sounding jaded.
We can address that in the Q&A, the written Q&A later, right?
It's a bit of a problem. Some of the stuff is really complex. It's beyond me. We've got a big binder on the Employment Standards Act with all the cases that are related to it, and still I find it difficult. So any of you who find that process difficult to navigate and understand, I've got great sympathy for you.
Well, thank you very much to both of you for your time and for your excellent answering to all those questions. So yeah, I'd like to thank you both again for an excellent presentation and for your time. We'd like to thank the attendees for their questions. And as mentioned, we'll be sending the link to this recording and to the visual recording piece to all the participants within the next short while. And the recording will also be hosted at on the BCNPHA website at bcnpha.ca/education/webinars. For more COVID-19 resources and upcoming education webinars, please visit the BCNPHA homepage at www.bcnpha.ca. Thank you very much again, and take care, everybody.
Thanks. Bye.